Including my chair.
When you are.
Good evening, ladies and gentlemen. Welcome to Fredonia Village Hall on this January 21st, 2025 at 5 p.m. This is a public hearing. This time and place for the public hearing on local law number 1 of 2025 entitled Local Law Opting Out of the Exemption from Taxation under Section 487 of the Real Property Tax Law for the Village of Fredonia, New York. Proof of the publication is shown, and I call this meeting to order. First, I'd like to read the Section 1 of the purpose of the meeting. The state of New York has adopted an exemption from tax for certain solar and wind energy, farm waste energy systems under Section 487 of the Real Property Tax Law, RPTL, of the state of New York. The law further provides that a village may provide that no exemption under this section shall be applicable within the jurisdiction by adopting a law to that effect, local law to that effect, excuse me. The Village Board of Trustees of the Village of Fredonia hereby wishes to adopt such a local law. Section 2, opting out of Section 487 of the Real Property Tax Law. Section 487 of the Real Property Tax Law of the State of New York, exempting from taxation certain solar, wind, energy systems, or farm waste energy systems shall not be applicable, nor available to such real property within the Village of Fredonia, Chautauqua County, New York. It is the express intention of the Board of Trustees of the Village of Fredonia in adopting this local law to exercise the opt-out provision afforded to local municipalities by Section 487, so that the exemption from real property taxation for solar, wind energy, or energy systems, or farm waste energy systems shall not apply nor be available within the Village of Fredonia, Chautauqua County, New York. Section 3, effective date. This local law should be effective immediately upon filing with the Secretary of State. Currently, we have no other people in attendance for this law, so we will wait.
Patient. Or not.
Chip, if you'd like to perform or dance, tell jokes, what do you want to do?
So we have to wait till 5:30 or?
Gonna close it.
We can close it within, what's the time limit in which we can close it, 10 minutes? Something. Until 10 minutes after
Yeah.
5.
Because of the weather too, the roads are slippery.
Realize it is
Called Anne Marie today and left a message on her phone that there was no approval of minutes. She forgot to put that down. So
Welcome back to Village Hall. Board of Trustees of the Village of Fredonia is holding this public hearing at 911 Church Street, Fredonia, New York, on January 21st, 2025 at 5:30 p.m. This being the time and place for the public hearing on local law number 2 of 2025, entitled Local Law Regulating the Installation, Placement of Solar Equipment and Systems in the Village of Fredonia. Proof of publication will be shown, and I call this meeting to order. Be it enacted by the Board of Trustees of the Village of Fredonia as follows. Section 1, purpose. The Board of Trustees of the Village of Fredonia, exercising the authority granted to it under the village law of the state of New York to protect the health, safety, and welfare of the residents and property owners of the Village of Fredonia. The purpose of this legislation is to balance the potential impact on neighbors when solar collectors may be installed near their property, while preserving the rights of property owners to install solar collection systems without access regulation. The Village of Fredonia recognizes the importance of solar systems in generating electricity for on-premise and off-premise use, the reduction of greenhouse gas emissions, and support for emerging solar systems economic development. Section 2, authority. The Board of Trustees, in enacting legislation, exercises authority granted to it under the New York State Constitution, Municipal Home Rule Law, and the Village Law of the State of New York, which authorizes the state to adopt zoning and land use provisions to protect the health, safety, and welfare of persons and property within the village. Section 3, definitions. Building integrated photovoltaic, BIPV, a solar energy system that consists of integrating modules into the building structure. Technologies include PV shingles of tiles, PV laminates, PV glass. Examples of placement include vertical facades, semi-transparent skylights, awnings, fixed awnings, and roofs. Collective solar installations owned collectively through subdivision homeowner associations, college student groups, quote, adopt a solar panel programs, similar arrangements, or commercial entities. Glare, the effect by reflections of light with intensity sufficient as determined in the commercially reasonable manner to cause annoyance, discomfort, or loss in visual performance and visibility in any material respects. Ground-mounted systems, a solar energy system that is anchored to the ground and attached to a pole or similar mounting system, detached from and other structure. Large-scale solar, Tier 2, solar energy systems located on land in the Village of Fredonia, used primarily to convert solar energy into electricity for off-site consumption or sale, and/or systems that have the capacity to produce more than 25 kilowatts per hour of energy. Net metering, a billing arrangement that allows solar customers to get credit for excess energy or electricity that they generate and deliver back to the grid, so they only pay for their net electricity usage. Roof-mounted systems, a solar power system in which solar panels are mounted on top of the structure of a roof, either on a flush-mounted system or as modules fixed to frames which can be tilted toward the sun at an optimal angle. Roof-mounted systems should be located on the roof of a permitted principal use or accessory structure. Small-scale solar, Tier 1. Small-scale solar means a solar energy system installed in place for the production of energy for consumption only on site, and that the capacity to produce less than 25 kilowatts per hour of energy. Solar easement, an easement recorded pursuant to the New York Real Property Law 335-B, the purpose of which is to secure the right to receive sunlight across real property of another for continued access to sunlight necessary to operate a solar collector. Solar energy equipment, energy storage devices, materials, hardware, or electrical equipment and conduit associated with production of electrical energy. Solar energy production facility, energy generation facility or area of land principally used to convert solar energy to electricity, whether by photovoltaic, concentrating solar thermal devices, or various experimental solar technologies, with the primary use of wholesale or retail sales of electricity. Solar panel, a device capable of collecting and converting solar energy into electrical energy. Solar storage battery, a device that stores energy from the sun, makes it available in electrical form. Solar thermal systems. Solar thermal systems directly heat water or other liquid using sunlight. The heated liquid is used directly for such purposes as space heating, cooling domestic hot water, and heating pool water. Section 4 will address applicability. A, the requirements of this section shall apply to all solar energy systems installed or modified after the effective date of this local law, excluding general maintenance and repair. B, all solar energy systems shall be designed, erected, and installed in accordance with all applicable codes, regulations, and industry standards as referenced in the New York State Building Code and Village Code, as well and National Electrical Code, NEC, local regulations. Under state seeker regulations, actions are grouped as Type 1, Type 11, or unlisted actions. Type 2 actions are exempt from review and include actions such as construction, expansion, placement, or mere accessory structures. The Village of Fredonia considers building integrated solar components and small-scale Tier 1 to be Type 2 actions and therefore exempt from all seeker requirements, including the submission of an EAF environmental assessment form. Large-scale and solar production facilities Tier 2 that meet the thresholds contained in the seeker regulations and are considered more than likely than others to have significant adverse environmental impact shall be considered Type 1 actions. However, the need for complete environmental impact statements, EIS, shall be determined by the permitting board in accordance with the significance of the potential adverse environmental impact. Section 5, solar as an accessory use / structure. This section governs the placement and installation of small-scale Tier 1 solar as defined therein. The installation of small-scale Tier 1 solar energy systems does require the applicant to obtain a building permit from the Village of Fredonia. A, roof-mounted systems. Roof-mounted systems are permitted as an accessory use in all zoning districts when attached to a lawfully permitted principal structure and accessory structures, subject to the requirements set forth in Section 1, height. Solar energy systems shall not exceed maximum height restrictions within the zoning district and are provided the same height exemptions granted to building mounted mechanical devices or equipment. Set 2 setback. Solar energy systems are subject to the setback requirements of the underlying zoning district. 3, glare. All solar panels shall have anti-reflective coatings, and proof of such must be provided within the planned site application and building permit application. 4, aesthetics. Solar installations shall incorporate the following design requirements. 1, solar energy equipment shall be installed inside walls and attic spaces when possible to reduce their visual impact. If solar energy requirement is visible from a public right-of-way, it should match the color scheme of the underlying structure. 2, roof-mounted panels facing the front yard must be mounted at the same angle as the roof surface with a maximum distance of 18 inches between the roof and the highest edge of the system. 3, access and pathways. Ground access, roof access, pathways, and space requirements for solar photovoltaic systems shall be provided in accordance with the building code. 4, size of solar photovoltaic array. Such equipment array shall not extend beyond the roof line. Where required by the building code to allow for smoke ventilation operations, panels and modules shall not be located less than 18 inches from a roof, ridge, or peak. B, ground-mounted systems. Ground-mounted solar energy systems are permitted as an accessory structure in all zoning districts subject to the requirements set forth in this action. 1, all ground-mounted solar panels in residential districts shall be installed in the rear yard. If a side yard installation is applied for, it shall be subject to all setback requirements under the underlying zone district, and such application for a side yard installation shall require plan review by the Village of Fredonia Planning Board. 2, setback. Ground-mounted solar panels are subject to setback requirements of the underlying zoning district. 3, height. Solar panels are restricted to a height of 15 feet when located with a maximum setback distance of 10 feet from a lot line, a height of 20 feet when located within a minimum setback distance of 15 feet from a lot line, and a maximum height of 25 feet when located with a setback distance greater than 25 feet. All height measurements are to be calculated when the solar energy system is oriented at maximum lift. We have a reference chart included here for future reference. 4, lot coverage. The surface area of the ground-mounted solar panels shall be included in lot coverage and impervious surface calculations. It shall not exceed 30% of the lot. 5, any application for installation and placement of small-scale solar energy systems under this section in the side yard location shall require an application containing a site plan showing the location of all solar energy system components, their location on the premise, and location on the premises in relation to the property line, and any and all structures on the premises and nearest structure located on the premises adjacent thereto. 2, the site plan for such installation shall be reviewed by the planning board of the Village of Fredonia, and approval of the site plan for the placement in the side yard by affirmative vote and majority vote of the planning board of the Village of Fredonia. 3, glare. All solar panels shall have an anti-reflective coating or coatings, and proof of such must be provided with the site plan application and the building permit application. Section 6, solar as a principal use. A, large-scale solar systems, Tier 2. Large-scale solar systems Tier 2 are permitted by the issuance of a special use permit within zoning districts M1, C2, and 1-1 only. In addition to the requirements set forth in those sections, the following applies. 1, large-scale solar energy systems Tier 2 shall comply with all bulk area requirements, including height and setback of the underlying zoning district in which it is located, together with the following area requirements and setbacks, whichever is more restrictive. In addition, such other restrictions on placement, height, location, whichever is more restrictive. In addition, such other restrictions on placement, height, location, and setback and/or buffers may be imposed during the special permit process by the Board of Trustees. Each and every part and/or section of the solar energy system shall be set back the following minimums. 1, 300 feet from the edge of any public right-of-way. 2, 250 feet from each property line bordering the premises, which are subject of a solar application for special use permits. 3, 350 feet from any residential premises on any adjoining property. 4, at least 50 feet from the structure on any premises hosting the solar energy system. 5, no part of the solar energy system and/or its components shall exceed 35 feet in height. And 6, in the sole discretion of the village board, good cause shown after public hearing, and board may vary the strict applications of these regulations. Before I go any further, I want to point out that I made a mistake on the front page of the Observer with regards to saying that there was 1,000 feet right-of-way from the edge of the properties. And that was a proposal, but that was not on the final draft. So again, that was my mistake. 2, large-scale solar systems, Tier 2, shall be located on lots with a minimum lot size large enough to accommodate the proposed system. Lot coverage. The surface area of the solar system, energy system, including but not limited to solar panels, utility or electronic sheds, and any other part of the system, shall be included in lot coverage, together with any impervious surface calculations, all of which shall not exceed 50% of the lot size coverage of the premises on which the solar system is to be constructed, and which is the subject of the application and permit review. No large-scale systems, Tier 2, will be permitted to be located on multiple parcels. The parcel or parcels which are the subject of the application to host solar energy facility system shall be under the control of the applicant for and during the entire life expectancy of the solar energy facility system. 3, all large-scale systems, energy systems, Tier 2, shall be enclosed by fencing to prevent unauthorized access. Warning signs with the owner's contact information should be placed on the entrance and perimeter of the fencing. The height and type of fencing shall be determined by special use permit process. 4, on-site electrical interconnection lines and distribution lines shall be placed underground unless otherwise required by the utility. 5, the removal of existing vegetation is limited to the extent necessary for the construction and maintenance of the solar installation. 6, special use permit requirements. Every application for a special use permit under this section shall contain the following material. 1, verification of utility notification. Foreseeable infrastructure upgrades shall be documented and submitted. Off-grid systems are exempt from this requirement. 2, name, address, and contact information of the applicant, property owners, and agents submitting the proposed project. 3, if the property of the proposed project is to be leased, legal consent between all parties specifying the use of the land. 4, site plan. Site plan approval and issuance of permit of any application under this section shall go before the permitting board. Every application for a large-scale solar energy system, Tier 2 within the village of Fredonia, shall be made to the Village of Fredonia Board of Trustees and shall be approved by a majority vote of the Board of Trustees. Prior to Board of Trustee review of the application, the Board of Trustees of the Village of Fredonia may refer said application to the Planning Board of the Village of Fredonia for site plan review, report, and recommendation for approval or disapproval by the Planning Board to the Board of Trustees. A public hearing upon 10 days' notice, duly posted and published in the official newspaper of the Village of Fredonia and on the bulletin board of the Village of Fredonia before granting any such special use permit described here under. The Board of Trustees of the Village of Fredonia hereby reserves the right to delegate to the Planning Board, the Village of Fredonia, the public hearing requirement. And if so, such public hearing shall be held by and before the Planning Board of the Village of Fredonia, as we're doing right now. 5, blueprints signed by a New York State licensed engineer or registered architect of the solar installation showing the layout of the system. 6, the equipment specification sheet shall be documented and submitted for all photovoltaic panels, significant components, mounting systems, and inverters that are to be installed. 7, property operation and maintenance plan. A property operation and maintenance plan is required describing continuing photovoltaic maintenance and property upkeep, such as mowing, trimming, etc. A decommissioning plan, number 8. 1, to ensure the proper removal of large-scale systems, Tier 2, a decommissioning plan shall be required. The plan shall include the removal of all infrastructures and remediation of soil and vegetation back to its original state prior to construction unless otherwise permitted. A cost estimate detailing the projected cost of the executing decommissioning plan shall be prepared by a professional engineer licensed in the state of New York. Cost estimations shall take into account inflation. Further, all such plans shall meet requirements adopted, recommended by the Chautauqua County Planning Department as then currently in effect. Financial surety, number 2, a form of surety through escrow or equivalency of shall be established prior to the commencement of construction to cover the cost of decommissioning the site. The amount of surety required by the municipality may not exceed 125% of the estimated cost to decommission. Section 7, solar storage batteries. If a solar storage batteries are included as part of the solar energy collection system, its location, placement, and maintenance of shall be governed by and in accordance with New York State Uniform Electrical Code and all regulations promulgated under state code and national electric code. When storage batteries are no longer in use, they shall be in accordance with the law of New York State and any other applicable federal, state, or local disposal rules and or regulations. Section 8, violations. Any violation of the solar energy law will be subject to the same enforcement requirements, including the civil and criminal penalties provided for in the zoning or land use regulations of the village. Notwithstanding the above, the Board of Trustees of the Village of Fredonia hereby reserves the right to proceed to enforce the provisions of this local law by civil action, injunction, and any other remedy afforded to it under the laws of the State of New York or the United States. Section 9, validity. If any part or provision of this law or the application thereof to any person or circumstance be adjudged invalid by any other court of competent jurisdiction, such judgment shall be confined in its operations to part or provision of application directly involved in the controversy in which such judgment shall have been rendered, and shall not affect or impair the validity of the remainder of this local law or the application thereof to other persons or circumstances. Section 10, effective date. This local law shall be effective immediately upon filing with the Secretary of State.
There's that half hour.
There you go. Were you here to speak to it, Jim?
Nope.
Okay.
But thanks for
I saw that, no?